Hello, this is Robert.
Good morning, Robert. This is attorney Adam Chaya calling you from the Keith Taylor Law Group.
Good morning. I'm glad that you gave me a call. Thank you.
Yeah, I'm giving you a call. I heard you had some questions for me about a potential probate for your mom's estate. Is that correct?
That's right, yes. Is it okay if I record the call just so I can make sure that I'm able to retain everything that my brain may not at the...
Yeah.
Thank you so much. I appreciate that. But yes, I do have some questions. My mother passed away on November 6th, so last Thursday.
I'm very sorry to hear that.
I thank you so much for your kind words there, Adam. She leaves behind a house that still has a mortgage on it, and she leaves behind a car, a 2005 Buick. She also has a house full of stuff that, I'm not quite sure what we're going to do with yet. My brothers and sisters, which are all younger than me, are looking to me to, get this settled. So, yeah, maybe you could tell me what kind of services you offer, and I've never had to go through this before.
Okay. Did your mom have a last will and testament?
There is no will. It's an intestate scenario.
Okay. Have you live?
I'm sorry?
Where do you live?
I live in...
Where's your...
Yeah, I live in Pasco County.
Okay. And the house that we're talking about here is 426 South Washington Street, Beverly Hills. Is that correct?
That is correct.
Okay. And are there any stepchildren involved, or is everybody the biological children of mom and dad?
Well, 5 of us are biological from the same mom and dad, and then there's another brother that is our half brother from another man. Was my mom's youngest.
Okay. I'm just taking some notes here.
That's
so
okay. Take your time. I know you're helping me, so take your time.
And you said, so there's a youngest child from a previous relationship that was not also the child of Paul Wehrman Jr.
Okay, so Paul Wehrman, that was a new marriage after our father.
Okay.
So, in other words, the youngest, my half brother, there's no father or marriage or anything. They actually have been, no longer together. My mom and that man for many years.
Okay. But Paul Wehrman Jr. is deceased.
He is, yeah. He died, I believe, about 2 years ago.
Okay. And they were married at the time of his death?
They were.
Okay. What about financial accounts and things like that? Have you been able to access any of those checking account savings?
I have not accessed any of it, but I do have the paperwork that has the account numbers and what have you on it.
Mm-hmm. Okay. And are those accounts, do they have beneficiaries listed on them? Or do they have co-owners that are not Paul?
Sure. So my mom is listed as the sole owner of the checking account. However, she did have a beneficiary on the checking account, which is my sister June.
Okay. Okay. Is it pay on death? How do you know that she's a beneficiary on that?
The paperwork that I have from the Regions Bank is listed that way. It says sole owner Catherine Simonu, and then it says beneficiary and has my sister's name and her Social Security number.
Okay. Did your mom have any other accounts other than that checking account?
Not to our knowledge. Not to our knowledge.
Okay. Any life insurance or anything like that?
Not to our knowledge. I did, in going through things, I did find an old policy from 1993, but I highly doubt that it was paid it's been paid all these years.
Okay. All right. So really, as you were saying, so the checking account, obviously, because there's a beneficiary on it, and it's your sister, she would be able to get that, regardless of whether there was a will or not. It's separate and apart from your mom's estate, we would say.
Okay.
Because she's a named beneficiary. And if you do find, any other assets, like checking accounts or life insurance, IRAs, money market accounts, things like that, that did have a beneficiary listed directly on them, those assets pass directly to the named beneficiary.
That's quite understandable.
Okay? So she would not have to probate that account. She can go to the bank and get the funds right away, and they're hers.
Okay.
Now, the property, the real property, the estate, the homestead, her primary residence. Does she have any other real estate other than this property in Beverly Hills? No.
Or not to my knowledge, but I would say no.
Not to your knowledge. Okay. Because I'm looking at the property appraiser's website right now, and there doesn't appear to be a homestead exemption, but they just may not have applied for it. So that's okay. It looks like Paul so your mom's name is Catherine, is that correct?
That is correct.
Okay, so because they own the property as a married couple, when Paul passed away, his interest in that property passed directly to Catherine.
Correct.
Outside of probate, just by virtue of being on the deed itself. Says the property. Okay, so if you wanted to, just to clean things up on the title, take Paul's name off of that property, you would just need to record a copy of his death certificate, and then it would show up on the property appraiser's website. You don't necessarily have to do it. It's, it would just be a way to sort of clean up that break in the chain of title. But now Catherine's interest in the property, because there's no one else listed as a beneficiary on this real property, is now considered in her estate.
Correct.
Now, the second question we have to figure out is, what do we need to do with it? What is practical to do with it? Those could be two separate answers. So what do you need to do with it is, it is subject to probate, meaning if you wanted to convey the interest in this property to Catherine's children, you would have to go through a probate proceeding and have the property transferred directly to her heirs, which would be her children, since she's not married. Excuse me. The question that hangs out there is the mortgage. All right, so you mentioned there's a mortgage on the property. Do you happen to know the balance of the mortgage?
I do have a recent statement.
Okay.
I have it's October's statement.
Okay.
I'm not quite sure exactly how to read it, but I can tell you that I believe there's maybe an $80,000 balance on it. Okay,
so maybe something it'll say, it's hard for me to say, but sometimes it'll say like principal balance.
Sure, let's take a look.
That, or principal. Okay.
So the principal balance is $85,444.43.
Okay.
This is on an October statement.
Okay. Okay. So there's about $85,000 due to the bank. Now, that is going to, because it's a mortgage, it's a lien on the property itself. So it runs with the property. What that means is that you and your siblings, your mom's other heirs, do not have an obligation to pay it. It's an attachment to the property itself. However, if you want to sell this property or you want to get title to it or however you want to deal with it, the mortgage is going to have to be satisfied. Okay? Now, whether that's through proceeds of a sale or whatever it is, it's going to depend on the value of the property. So what I'm trying to get at is it worth probating this? Because what I don't want you to do is go down this road of probate and basically do the lender, the banks, work for them, right? So if you sat back and walked away from the entire thing, okay, so you did nothing, the bank would foreclose on their mortgage and they would take title to the property and sell it. They would have it auctioned off, and if they could make $85,000 on it, then they're going to be happy. But what they're trying to do is just satisfy what they're owed. They're not trying to get the maximum amount that you would get through like a realtor or something like that, right? So if the property is worth $150,000 or whatever it is, it may be worth probating because although you would have to satisfy the mortgage, you may get something at the end of the day.
Right.
So what I don't want you to do is throw good money at bad and go through all this, probate work and just hand the property over to the bank. If you're going to do that, just let them do it. So do you have any idea of what the property is valued at?
Well, I know she paid $92,000 for it. I know in recent years there is a bit of a housing bubble, so I do know that, and I do know things sell rather fast over in that Beverly Hills neighborhood. I think what all of the children are looking for, however, is to get it sold, and if every kid gets a couple $1,000s out of it, that's what we're looking to do. On the other hand, I am willing to put my hands in the air and just let it go to foreclosure and forget about it. But at the same time, I have other brothers and sisters that I'm obligated to in this in this scenario, and that's what everybody's looking for. As none of them are ready to take mom's house and pay her mortgage. In other words.
Mm-hmm. Okay. So you mentioned the word obligated. You're obligated, okay? So here's what I don't want you to think that you're doing is you're not legally obligated to do anything, okay? That may be different than I am morally or familially obligated to my siblings to do something on this.
I get it. I get it.
But from a legal standpoint, you don't have to do anything.
Okay.
They could have the same practical standpoint where I know I'm not legally obligated to do it, but I have to see my family at the holidays, and I don't want them to wring my neck if I don't do what I do here.
I get it.
That's different than you have a legal obligation to do something. I don't want you to think that you do. You are not the personal representative or the executor of the estate. Even if they nominate you to be one, you are not that yet. You are appointed by a judge if you do want to go down that road, but you do not have a legal obligation to pursue this. Okay. What I would probably want you to do before you took any action, because I want you to be fully informed of what you may and your siblings may be getting out of this deal, because what your mom paid for the property, obviously that's different from what it's worth now, potentially, and the balance is so high on that mortgage What I'd probably advise you to do, just before you start out doing anything, is go to a real estate agent or realtor or something like that and try to get what's called a comparative market analysis, or a CMA. And if you've ever had to deal with them before, what it is basically, the realtor does whatever they do. They analyze the market, and they tell you what they would probably list the property for and sell it for. And I think that you're going to be going into this a little bit better armed, and it's not a guarantee or anything like that.
Right.
But if you can get a realtor to come out and say, hey, listen, based on the market, this property is worth $150,000, then I think that, although you're splitting it possibly 6 ways,
right,
you're looking to get at something at the end of the day here. You're not throwing good money at bad. And it may be in your best interest to do something like that, just so that you're better armed. If that realtor comes back and says, "Hey, listen, I think that this property I probably listed for $86,000," I don't think that it's probably worth probating in that case, right? Because you'd have to pay out the mortgage. So, do you have any idea of if there's any other debt in Mom's estate? I know that she just passed away recently, but are you aware of any kind of credit card debt or medical debt or anything like that she made?
I will say that she really cared about her credit. I know that. I can't really find any type of evidence of bill collector types of notices, and she was a pack rat, and literally I was going through mail from the 1990s, I promise.
Right.
I didn't find anything such as that.
Okay. It's good to get a head start on that now. So, I mean, what you would probably want to do, if your siblings have no objections to it, is get her mail forwarded to you.
I did that. Already.
Okay, yeah. Start going through it. If you're seeing things like Visa bills come up, any kind of last medical bills come up, don't pay them.
Right.
Okay? Don't pay them. Put them in a separate folder. Because whether or not you want to pursue a probate with regard to the home, you are not, and your siblings are not, even June, because she is listed as a beneficiary on that account, you are not obligated to pay your mom's debts.
I understand.
Okay? Yeah, it's something that's very important to understand, because a lot of people feel like, oh, this medical bill's coming in, I should pay it. Even June, she got that money in the checking account. Even if it's not a lot of money, a lot of times she may feel an obligation to pay off, a credit card or whatever it is. You are not legally obligated to pay any of her debts.
I understand.
Okay? Debts are dealt with via the probate process. Okay? So, if you wanted to pursue a probate, the process is trying to figure out if there are any creditors, serving them with notice. However, the homestead property and the interest in that homestead is protected from creditor claims, not including the mortgage. Okay, so what that means is, although the mortgage holder, the bank, the lender, they can foreclose, and they're entitled to whatever they're due. Okay. If mom had a hospital bill or a Visa bill or something like that, they cannot attach that to the interest in the property.
I understand.
The homestead property. Okay? So that's good. So at least you know what you're looking at. You still have an obligation to notice creditors and things like that by the probate, but they're probably not going to be able to attach their interest also to that homestead. Okay? As far as the vehicle is concerned, you may want to just try going down to the DMV and getting it transferred out. Is there a lien or anything on that vehicle?
No, I think it's paid off completely. It was a digital transfer of the title. Okay. And my brother, however, my younger brother has the vehicle in his possession right now. I wasn't quite sure how to handle that either, but I guess we'll just, I don't know.
What do you guys want to do with it?
Well, I mean, we want to sell it with the house, but I mean, like I said, my brother has the keys, and I don't know quite what to do at that point.
Okay, so it's an asset of the estate. technically.
Agreed.
So nobody really has a right to possess the vehicle because it is an asset of the estate, and there's been no personal representative appointed. Now, from a practical standpoint, he's got it. So I think that everybody would be better off trying to get together and figuring out, okay, does anybody want this vehicle? What is it worth?
Right.
I don't think that the transfer in interest of that vehicle is going to be that big of a deal.
I
think that once you guys figure it out, you can go down to the DMV, say mom didn't have a will, no debts that we are aware of, other than the mortgage, and in all likelihood, I think that the DMV will just transfer it out either to the 5 or 6 of you or to the person that you all agree to transfer it to, and then you can sell it. It's a similar thing with the personal property. You were talking about, there's a bunch of stuff in the house. Although these are assets of the estate, technically, they don't really have title to them, like a house has a deed, or a bank account has ownership on the account itself. So these are things that don't often really need to be probated.
Okay, what about
really
any firearms that might have been in the home?
Firearms?
Sure.
I mean, obviously you can't transfer them to an individual that is not qualified to possess a firearm.
Of course.
However, they're considered just to be like any other asset.
Okay.
You can have everybody, every way to deal with personal property. Sometimes it's easier to deal with than a bank account. Sometimes it's a lot harder.
I understand. I just thought I would inquire about that.
Yeah, I mean, what I sometimes like doing, if everybody, wants some stuff in there, is basically give everybody a chance to come in and not necessarily take anything, but make kind of a list of the things that they want, and just kind of compare and contrast those lists between everybody else, and just see if you can work it out fairly amongst yourselves. I mean, you always do have the ability to go to the court because, like I said, they are a probate asset, technically, all the stuff. However, if you go to the judge and you say, Judge, there's a bunch of personal property here, and we can't agree with how this stuff is supposed to be distributed amongst the 6 of us, the judge is just going to say, okay, I'm going to order it all to be sold, and then we're going to split the money 6 ways.
I thank you.
So,
that's great advice. It's kind of leverage that I sometimes use from people who are, bickering over the pots and pans because a lot of times they don't want that kind of a thing. If we just say, hey, we're going to lock the door, we're going to go to the judge and tell her this is what's, we can't get along with this, and then she's going to order it all to be sold in an estate sale, and then we can split the proceeds. If everybody's cool with that, then that's fine. If not, then you all can get along and try to work this out equitably amongst yourselves. And everybody can go their separate ways. I understand. Okay, you have been just most helpful. Most helpful. Can you give me a rundown of the money aspect before we end this and figure out where we're going here?
So
if we just want to sell the house, we just want to do probate, just for the house only, right? Mm-hmm. Get it sold. Anything that's extra, you come into the kids, get split 6 ways, and we all go our separate ways. That's what they're even though I'm not really legally obligated to do any of this, I'm the one that they're looking to get that answer today.
Mm-hmm. I think, sure, of course. I think our fees are usually around $2,500 for the attorney fee. For the costs associated with it, you're probably looking at about $1,000 in costs. So court costs, publication fees, and miscellaneous expenses that might incur, like mailing fees and potentially a bond, things like that.
Is any of this paid out of the probate?
Normally, it would be. However, because the homestead property is exempt from creditor claims, it really isn't. It can be included as reimbursement on the settlement statement if you sell it. However, homestead property is, and I don't want to get into the weeds with how homestead property, because it's a mess in Florida if you've ever had to deal with this.
I understand.
It's so almost like not considered an asset of the estate because the title passed directly to the beneficiaries upon the decedent's death. However, you are not going to be able to sell the property through a title company without having to go through some sort of a legal proceeding in order to get the property not transferred out of the estate, but confirmed that it's homestead. Right, if that makes sense. So the judge basically signs an order saying, yes, this property transferred upon Catherine's death to the following individuals, and it's exempt from creditor claims. That's what you get at the end of the day going through all of this. And that kind of acts for all intents and purposes like a deed, where then you can sell the property outright. If you don't do anything, if you decide that the property is not worth it, let's just let the bank deal with it. They can hire the lawyer and do it themselves. If there are any proceeds that are left over, so let's say there's like $20,000 that the bank is not entitled to. They are only worth 80. They're only paid 85. And sold for 100. The estate would then be entitled for the surplus proceeds. Okay, and then you can do, depending on if there's any debt, you may be able to do a quicker, more abridged version of probate, but that's kind of a different conversation. Okay. But if you don't do anything, it's not like, I don't want you to think that if they sell it for $100,000, they get $100,000.
I understand.
Right? They just get what they're owed.
I understand.
Right? Mm-hmm.
And what would Keith Taylor Law Group? What exactly would they be looking for up front monetarily?
Probably, obviously the attorney fee, and then we want to hold some funds in trust in our trust account. So if you've ever had to hire a lawyer, what we have are kind of like two bank accounts. One is our anything that's due to us, like attorney fees, and then we have another account that's just your money that we hold in there that we pay things like the filing fee to the court out of, or we have to publish a notice to creditors in the newspaper. We pay it out of that. So I like if possible to hold about $1,000 for a probate in there. Sometimes it goes over a little bit. Sometimes it's under. If it goes under, then we will reimburse whatever we don't use out of that to you guys. So probably looking at about $3,500 to do a probate like that if you decide to do it.
Okay. So,
I'd say.
All right. Well, listen,
including costs and things like that.
I really appreciate you. I'm going to share this conversation with my brothers and sisters, and your name was Adam, correct?
That's right, yeah. If you need a split or anything like that. But again, I want you really, before you hired us, to see if you can get a better idea of what you could probably sell that property for, whether you go through a CMA or I don't know. That's usually what I recommend doing, just so that you have a good, clear idea. I just don't want you guys to get hosed by the bank on this one and do all of their work for them. And if you can, I can recommend some real estate agents and things like that. Of course, they're sometimes a dime a dozen. My parents are real estate agents, so. But
Well, let me ask you, Adam. Did I
hire a good one and then see if?
Did I leave an email address with the secretary that booked our appointment today?
Let me see here. I don't see one.
Do you mind if I provide you one, and you could definitely shoot me some physical documentation there? It's Revere, like Paul Revere, REVERE, radio @gmail.com. Okay.
Yeah, let me send you some recommendations, maybe. I'll give you a bunch of them. And we work with a lot of them, obviously, for a lot of different reasons, but they're all pretty competent and easy to work with. So if you can talk with them, just say, hey, listen, this is what we're trying to do. I'm sure they're very familiar with this situation here, especially with probate involved. And another thing you have to do just before I get you off the phone here, if you do decide to list the property, let's say you can list it for $100,000 or whatever it is, and it's worth probating, what you really need to be able to do is to tell the prospective buyer. They're coming in. You need to tell them that and make them aware that this is a property that's going through probate. And therefore, they shouldn't be expecting to close within 30 days, right? It's going to take a few months, at least probably 5 months on a good day to go through this process. So it is important for them to be aware of that so that they don't get mad at you for delays and things like that. Just so everybody's on the same page. And that can also be reflected in the price, too, which is something that you should take into account.
I understand. I thank you so much for your time, and you've been so kind, okay?
Sure. If you have any other questions or anything, let me know. No rush on our end for you here, but obviously this is an asset that's a little bit different than just a bank account that's sitting there, because if we're not keeping up the mortgage payments,
right,
the mortgage company is going to foreclose. I'd probably advise you not to tell the mortgage company that mom has died.
I understand.
If you haven't already, just because if they do, then you might get a default notice in the mail anyway. Just kind of keep kicking that can down the road if you have the ability to do so. But I'll shoot you an email with a bunch of recommendations for realtors around here, and hopefully you can get a better idea of what the property's worth and if it's worth pursuing this. Okay?
I thank you. You have a great day now.
Thanks very much. You too.
Bye-bye.
Bye-bye.